Good afternoon, everyone. Welcome. Thank you so much for joining us today. Welcome, welcome as everyone files into the room. Um, as you all know, I am Cassie Seaton. I am the Outreach Marketing Director here at the Strip Matter firm. This year marks our 80th anniversary at the Strip Matter firm. Founded in 1945 in Hoquiam, Washington, we take pride in continuing to serve the community where our story began and while operating our main office here in Seattle. Over the decades, three of our senior partners have served as presidents of the Washington State Association for Justice, and our namesake, Paul Strip Matter, also served as the president of the Washington State Bar Association. The WSBA has licensed the Strip Matter firm as a sponsor of mandatory continuing legal education. And today's webinar has been approved for one Ethics Equity CLE credit. And to receive this credit, please stick around until the end, at which I will ask you to confirm attendance by entering your bar number into the chat. And so throughout this presentation, we encourage you to submit questions to the Q&A box or the chat. So for today's speakers, Edward Moore has practiced personal injury law for over 40 years. His current practice focuses on medical malpractice and police civil rights cases. Over his career, Ed has tried over 100 cases in both criminal and civil court. He is a graduate of the University of Texas School of Law, licensed in both Washington and Texas, and board certified as a personal injury trial lawyer by the Texas State Board of Legal Specialization. And Mo Hamoudi is a former federal public defender who transitioned into the civil arena. He focuses on police civil rights cases as well as significant personal injury and wrongful death cases. Mo has tried numerous jury trials and is a graduate of Seattle University School of Law. And so at this time, I'd like to hand it over to Mo and Ed. Thank you.
I got to make a correction, Ed. I didn't graduate from Seattle University School of Law. I'm an adjunct there. I actually graduated from a smaller law school in the Bay Area. But this is wonderful. It's Black History Month. Talking to Edward Moore, and we're going to talk about the Ku Klux Klan Act. We're going to talk about modern police injury civil rights law. And we're doing this because there's a new CLE under the Washington State Bar Association, and it's an ethics equity. And I just want to tell you what that means. Equity credit is for activities in the topic of equity, inclusion, and the mitigation of both implicit and explicit bias in the legal profession and the practice of law. And you're required to report it. The starting period is 2023 to 2025. I can't think of a more relevant topic now, in this day and age, on this month, to talk about. I want to talk a little bit about Black History Month, and I want to focus on an outstanding Black attorney, and I want to talk about Ed and his career. Ed, will you tell us a little bit about your work, you and your work here at Strip Matter?
Well, I've been of counsel to the firm since 2020. I actually co-counsel some cases prior to that and office shared here since I moved to Seattle from Texas in 2009. And I'm currently of counsel working on cases of my own as well as cases with the firm.
And what kind of cases you work on, Ed? I know there was some discussion Cassie gave us in the introduction.
Well, as it turns out, kind of without any planning, I end up only handling medical malpractice and police brutality cases by and large is most of my docket today.
And can you tell us a little bit why it's important for you to handle, or things that are important to you about handling those types of cases? What motivates you to work those types of cases, Ed?
Well, like I said, it's kind of unplanned that's the focus, but I've been doing so many of those cases over the years that I have some thoughts about why I like doing the work and why it's important to me. Both are quite noble professions, medicine and law enforcement, but they both have a very disturbing Achilles heel, in my opinion. And that is that they often will hide the ball when mistakes or errors are made. Neither industry has a good track record of policing bad actors in the respective industries. And I find both cops and doctors rarely willing to accept responsibility for their mistakes that cause injury or death to others. And that's what one of the things that motivates me, because in my practice, I get to help them accept responsibility for mistakes when they rarely will do so voluntarily. They rarely will do so in their answers, in discovery, at trial. And you have to shine the light into the place that they want to be kept dark and evasive on. And that's something that's very interesting to me.
Now, you say it's interesting to you. You know, you've been doing this now for 40 years. You've been in the trenches. Can you just briefly tell us how from sort of an educational background, how did you end up here?
Well, I mean, if you're asking me about my educational preparation, so
Yes, sir.
the first thing is that my mom was my biggest fan, and she was a school teacher. She had me do an Iowa basic skills test before I ever went to kindergarten. When we lived in Houston, there were minority to majority transfers, and she had me at the best public schools in the city. We knew kids who were getting scholarships to preparatory schools around the country. The local contact for a scholarship fund known as the Ann-C. Stouffer Fund was a friend of my mother's from the school district. I know it's wrong, but when I took the secondary school admission test, they claimed that my scores were off the chart. I've never done that well on any other standardized test, so I know that was a fluke. But I got to go to the very top prep high school in Atlanta as a boarding student, and ended up attending Morehouse College, got my degree in political science. My advisor said, well, you can apply to those Ivy League schools, Ed, but the University of Texas Law School is actually in the top 20. And as a resident, your tuition's going to be dirt cheap. Those many, many, many years ago, my tuition was $1,000 a semester at the University of Texas Law School. So that's sort of the educational path that's taken me and prepared me to begin my legal career.
So when you began your legal career, you passed the bar down there in Texas. What year was that? What about year was that?
I got licensed in October of 1981. I
19.
graduated from UT Law School that year. The UT Law School had a great placement program to help you get jobs out of school. Yeah, these big books at the time, nothing was computerized, and all the law firms around the state or outside of the state that were recruiting. I was eager. I signed up for 36 different firms. I got no response from 35 of the 36. And the only one I got a response from was the Houston DA's office, and they never followed up with an interview. Lots of my colleagues who happen not to be African American had a lot better success with that placement center. But I had clerked for the AG's office for what I call a band of roving prosecutors. Clearly, the Trump administration would have cut this funding if they haven't already.
Yeah.
But basically, the state AG had a team of prosecutors who helped on big cases in small counties that didn't have the staff and the budget. I was their law clerk, and one of the guys I worked for was the assistant county attorney in Travis County. And that's actually how I got my first job as a prosecutor for the county attorney in Travis County, Texas.
So in the 1980s, young lawyer gets an opportunity through a clerkship. I mean, you know, we're talking here today, we're talking about equity inclusion, and we want to mitigate both implicit and explicit bias. Can you talk to me about some of the bias that you experienced as a young lawyer coming up in the 80s in Texas?
Um, you know, I'm never, I mean, this is not really that big a deal, but I can never forget on two separate occasions in two small counties, being talking, engaged with the court from the bench, at the bench. And I've introduced myself as Edward Moore. That's my name. That's the only name I've ever used. The pleadings have my name on it. There should be no excuse for the court not to know my name. But on two separate occasions, I've been called Mr. Brown. I just can't help but wonder if it's because I'm Mr. Brown. But
Yeah.
so, you know, I also remember trying a case. There's a small federal district court in Texas that became famous for patent cases being filed there. My co-counsel was, his mother was the clerk of that court, and we tried a case against Walmart where the boxes fell and injured my client, who happened to be an African-American woman. And so his mom knew knew a lot about what happened in the jury room due to her role as a clerk in a very small federal courthouse. And she recounted to us later that the foreman was a 70-year-old Caucasian. We were in deep East Texas, which is one of the historically most racist parts of a racist state.
Was it near Louisiana border?
Is very close to the border.
Yeah, yeah.
And his comment in the course of proceedings was, yeah, I know they were negligent. I know those boxes fell and hurt her, but I'll be damned if I'm going to give an N woman any money. And as a result, we got zeroed out. Now, you know, your question is interesting because I can't really escape the fact that people might view me or treat me differently because of my color. And I have a lot more success stories about the many jury trials that I've conducted all over the state of Texas. South Texas, predominantly Hispanic; West Texas, extremely rural and conservative; East Texas, North Texas. And I've had judges treat me in disparaging ways, and you don't always know if it's because of color or if because you're from out of town and they don't know you well. But the thing that has made me feel really, really good about my experiences trying cases in that state was that if you can bring a story to a jury that deserves the right result, my string of successes suggests that no matter what the judge thought about my color, no matter what the jurors may have thought about my color, other than that one case, I've been successful in almost all of those trials, gotten good results for the clients. So it's been inspirational to know that in spite of color barriers, you can take facts and the law and persuade a jury to do the just thing.
And then the natural follow-up question, Ed, is the question of today is today, in this day and a time, is discrimination alive and well?
Yeah, I mean, unfortunately, it is alive and well. And I mean, as a child of the 60s, who I always joke and say my mom had me integrating schools one step behind Martin Luther King. You know, as a youngster, I thought America was absolutely turning a complete new leaf. And obviously, there have been a lot of changes over time since then, but the specter of racism and the fact that human beings treat others differently still exists. The anti-DEI movement of today really is just code word for racial hate, is really what it is. Every time we hear the MAGA folks and Trump and Congress people decrying the efforts of DEI, it means we don't like people of color. We don't care that much for women, even if they're white. And we want to put the white man back on top. That's really what's happening these days. So Things have changed, but a lot of things haven't changed, unfortunately.
Well, let's go back in time, Ed. Let's go to history because, the purpose of our conversation here is the Ku Klux Klan Act. And I want to go back in time and ask you what I would call a challenging question, maybe not a challenging question, but are the events of today at all similar to the immediate post-Reconstruction era after the Civil War?
Well, let's talk about that. And I think what we're going to find is that the amount of similarities are rather striking, right? Because with the Emancipation Proclamation, the 13th Amendment, slavery was abolished in this country. And the hope, I think, was of the people who passed that amendment that America would turn over a new leaf about how we treated people of color, particularly blacks. But what we saw was that Reconstruction started out beautifully, but it quickly foundered and failed, quite actually. Black senators and representatives were not reelected after their initial situations. Laws, poll taxes, things that kept blacks from voting were enacted. Slaves essentially became sharecroppers, which is really a distinction without much of a difference. And the reason why is that Southerners actually conspired to gut the effect of emancipation, and they enacted laws and codes that were designed to keep the old order in place. And these gentlemen in their fine white robes and hoods were perhaps, the most obvious example of groups getting together to conspire to deprive the civil rights of people of color. And I guess when you rise to the top, you get this darker deal. I don't know exactly how that works, but
like that's like a promotion. You get a darker hood.
I think you get a dark one. It seemed like you'd get a whiter one if you got promoted to me, but I don't understand how that stuff works.
That doesn't make sense either. But haters gonna hate. Talk to me about this hate, Ed.
Well, so we got the Civil Rights Act of 1871, known as the Ku Klux Klan Act, that allowed President Grant to take action against what was effectively lawlessness in the South. He could suppress state disorders and use federal troops to do that. And actually, there was a suspension of the right of habeas corpus for a time. So the bottom line is it took martial law had to be put in place in the South in the post-Reconstruction era to stand the Klan down. And actually, it had the desired impact for a long, long time until we got to the 1920s when Klan membership was rampant across America through all classes, and millions of Americans joined the Klan. Thankfully, portions of the Ku Klux Klan Act have been codified now as Section 42 U.S.C. 1983 and two other important provisions that we'll touch on today, 1985 and 1988. And because these are private civil enforcement actions of constitutional rights and federal statutes, it's really been a transformative set of laws in the civil rights arena, despite all of the other changes like the Civil Rights Act of 1975, like equal opportunity agency being established. We still see violations of civil rights based on race and other impermissible factors. And what 1983 does is really gives us private enforcement actions.
Okay, before we hop on that, Ed, so just to sum real quick. So you have the Civil War, you have the North beating the South, and you have Emancipation Proclamation, and what you believe to be is a moment of change, but then that is suppressed and stopped by
It was
a
a
lot of
moment of
hate.
change. It was a
Huh?
moment of change. We had black senators, multiple black senators, multiple black congressmen. We had blacks being allowed to vote
So
after
we
the
had
Civil War.
progress.
We had progress, but in the South, and to some extent in the North, but certainly in the South, pretty quickly, Southerners decided they weren't going to stand for Reconstruction efforts, and they did everything in their power to gut the opportunities that had been given to former slaves. And that's what led to the Ku Klux Klan Act.
And in the Ku Klux Klan Act is the first piece of legislation that essentially gives the civil right of action to private individuals to enforce the promise of what was emancipation, of what was the Civil War's outcome, correct?
It was the predecessor of our current 1983 law that gives private enforcement actions to citizens to take action against people who violate the civil rights of others.
Okay, so let's talk about police brutality, government police brutality. But before we do that, does the civil rights statute, which is 1983, protect various protections in the constitutions through the Bill of Rights, various rights?
Well, I mean, the beauty of 42 USC 1983 is that any violation of any constitutional right can be actionable, right? And in addition, violations of federal statutes can also be subsumed in under the banner of a Section 1983 action. This includes things like the ADA Act. If, for instance, a case involves police who use unnecessary force against someone who may be using some level of force, excuse me, because of a problem with drug addiction or mental illness, right? There is a requirement under the ADA that reasonable accommodations be made if they're available for someone, even in the situation of an arrest. So you can bring an ADA claim, you can bring any other federal statutes that protect civil rights can be brought under Section 1983. It's a multi-purpose tool, although for purposes of our discussion today, we're really focused on police brutality, police injuries. And so the main things, you certainly don't rule out ADA, but the main sources of law that we utilize are the Fourth Amendment against unreasonable searches and seizures, the Eighth Amendment about unreasonable imprisonment and punishment, and the 14th Amendment, which is equal protection under the law.
Well, let's talk about the Fourth Amendment and let's talk about excessive force.
That's really the focus, right?
Yeah.
You know, Fourth Amendment protects against unreasonable searches and seizures. Well, why does that involve? Why does that address police brutality at all? Because when you take the club and you start knocking a guy upside the head, or when you shoot him and he stops moving, you have effectively seized that individual because you've restricted his freedom of movement. And that's why the Fourth Amendment is involved here. And with the Fourth Amendment, what you're really doing is you got to show excessive force. If you can't prove excessive force, you don't have a Fourth Amendment violation to bring under Section 1983. The force that's used by officers has to be justified by an imminent danger to either the officer themselves or to others in the near vicinity. And this standard, I think, has become it's problematic because law enforcement personnel are taught some limited aspects of constitutional law that help them in these 1983 cases. The Supreme Court wants us not to use hindsight. And I mean, let's be fair. Law enforcement and medical professionals, they've got tough jobs. Sometimes they've got to make life or death decisions under pressure without a lot of time to deliberate. But the law doesn't excuse violations of the Constitution simply because it's a tough job. It is a tough job, but most law enforcement professionals and most medical professionals do a good job, right? They're not bad actors. This law helps with the bad actors, but because of this focus on split-second judgments and what happens immediately before the officer uses force, it can be helpful. You don't get a lot of facts in the analysis. It's literally a snapshot in time. And the thing that fuels a lot of personal injury actions, negligence, is really not relevant to the consideration of whether the force was excessive or not. And it cannot, standing alone, justify or support a 1983 claim. So whenever the officer can say justifiably that he's in fear of serious bodily injury, you can use serious force, including deadly force. Now, this is an ABA publication, a book by a guy by the name of Bill Harmoning, and it's titled The Deadly Force Script because there's some good acting that goes on sometimes in police cases pursuant to a script. And it's taught to every police academy graduate. And the script is, I was in fear for my life. We heard this from Officer Chauvin in the George Floyd matter. No matter his knee on the side of George's head, he said he had to continue that because he was fearful for his life. Well, thank God for the video and the video cameras in all of our phones these days. It was the same thing in Rodney King, right? How many officers did it take to beat him? Well, they said he was under the effects of PCP and thus he had superhuman strength, and we were scared. But once again, the video told the tale, right? And so as a plaintiff's lawyer, to be successful, you've got to prove that the force that they used was not justified. And that's the starting place for these cases, excessive force. If you don't have it, you're not getting anywhere.
Well, you know, what you're talking about is you're speaking about a couple of things. One, legislators have authorized police officers to use force. They have a special authority that private citizens do not necessarily enjoy, in that they really are given by statute the right to carry a firearm, right to use that firearm. And then separately, what you're speaking to is police culture, training, and that a lot of what you're talking to, which is what's laid out by William Harmoning, is that the training protocols train officers to insulate themselves from accountability by using these types of magic words. You're training them in Graham v. O'Connor, which is the seminal case for deadly force. You're training to what the court is saying in Supreme Court holdings. And in doing that, you're essentially signaling to the officer that here's the framework to avoid liability.
Yeah,
and here's what you would need to do. Is that correct, Ed?
That's absolutely correct.
Yeah.
Police training and police culture have taught officers that if you can just create a fiction that supports your use of force, you're rarely, if ever, going to be indicted. I mean, we thankfully saw Jeff Nelson indicted here in our state over his history of multiple killings in Auburn, but rarely has that happened anywhere in the country. So, you know, I recall one case where I learned another chant that officers learn, especially when body cams and recording came into play. You'll hear them shouting, "Stop resisting," even if they're the aggressors, right? They've learned this chant. It sounds good on the tape to say, stop resisting, when the officers are actually the ones that are the aggressors and using improper force.
Well, it sounds like the counter tool, the productive counter tool that citizens have now is the advent of technology, the body cams, the phone videos that people are capturing. Because, I mean, I tell you, before these videos were available, I used to read police reports, and you know, you would be stuck with the police report. I mean, it was just by sheer chance in Rodney King that somebody had their video camera, old 90s VHS recorder, and recorded his beating. But that's been the game changer. Would you agree?
Absolutely a game changer. I mean, I hate to have to say this, but millions of Americans scoffed at Black claims of police abuse for years and years and years, until we started seeing them over and over and over again because of the cameras in our phones. Between those phones and body cams, we've had a real big sea change in the ability to prove what a lot of us, including the victims, knew was happening, but
Yeah.
oftentimes could not support a successful action because you had a half a dozen or so uniformed officers of the peace who told a different story from the victim, or the victim didn't survive to tell the story, right? So absolute game changer in the ubiquity of video cameras in our society today.
You know, there's some, you know, I always think, like, could you imagine there being body cams after emancipation, after there was an attack on the rights of people of color in the 1800s and 1960s? Could you imagine there being cameras and recording those acts? I mean, we have insight to the atrocities going on there, and then now we're able to get an insight, and what people have been saying for years, nobody can discredit. It's a great truth teller. But I want to talk about qualified immunity and how it provides a second quiver for or arrow for government and police officers to protect themselves against responsibility and accountability.
Well, they're going to trot out the deadly force script first.
Yeah.
And if the facts, either due to witnesses or inconsistencies in the officer's statements or video camera, they can't always get out that way. But there's another great tool that has foiled these cases in the past, and it's qualified immunity. This is a joke book from Gilbert Gottfried. I don't know that he ever told a joke about qualified immunity. It's not really funny, a funny topic.
Yeah.
But it has been appropriately considered as a joke when it comes to protecting officers and forces from being held accountable. There has been a campaign to abolish this, even though it's been upheld by the federal courts. It is a court-made doctrine, which many decry as being absolutely unfair to victims and way over favorable to police officers. And so this is, we'll talk in a second a little bit why. This slide makes it clear. The top half of it essentially says, when police officers act correctly in accordance with law and pursuant to department policy, qualified immunity has no role. Well, guess what? Because there's no case and nobody gets to talk about qualified immunity. But officers who are wayward, bad actors, those who want to harm citizens, qualified immunity can offer a level of defense and prevent our cases from being successful. The Supreme Court tells us that we're never going to prevail unless we can show that what the officers did violated clearly established constitutional law. And that might seem like a rather straightforward proposition, but it absolutely is not. This quote says it actually protects everybody but the plainly incompetent or knowing violators. And I suppose that is because if you got any competency at all, you learn the deadly force script, and you and the defense lawyer figure out maybe there's not a case on point and the case goes south. You gotta be able to point to an established constitutional right, the contours of which must be sufficiently clear that the officer understands that he's acting in violation of the law. Now we're told, as of 2018, in the Casella case from the US Supremes, that the establishment of the right has to be beyond debate. I'm missing something here. Okay, actually, it's what's before the yellow here. Case law doesn't require a case directly on point, but existing precedent must have placed it beyond debate. So
Yeah, I mean, that
let's
leads.
look at the next slide, right?
Yeah.
If you can't find a case on point, you should be very, very worried about your ability to help your client. That's the absolute lesson of qualified immunity. Because if the other side can distinguish almost anything about the facts of your case versus the specific facts of those that are on the books, you run the risk of losing your case to qualified immunity.
You know, I got to give a shout out to a fellow civil rights justice warrior friend, Lauren Friedenberg. She sent me a great quote from Judge Reeves, who is a fantastic judge on qualified immunity. And he wrote, a court let 5 police officers shoot a man 22 times as he lay motionless on the ground after tasing him 4 times, kicking him and placing him in a chokehold. It was not clearly established that officers could not shoot a motionless person who possessed the knife. I thought that was a very thoughtful way of sort of confronting this absurdity, which is qualified immunity, because sometimes actions and a picture tell 1,000 words about what it means to have something be beyond debate. But you are correct. This is an incredible obstacle to overcome, and a lot of it is dependent on which circuit you are practicing in.
It was a huge issue in the Charlena Lyles case that I helped the Strip Matter firm with, because she presented with a knife. And Casella, the 2018 US Supreme Court case, came out right as we were handling Lyles. And it really made us consider a different approach that maybe we'll touch on briefly, because negligence can be used often along with the civil rights claim. If we had not pursued the negligence claim, and if our Supreme Court had not supported the analysis to look at all of the facts, not just the snapshot in time before the force is used, we would have lost that case too. But we have good state negligence law to use in these matters, although our focus today has been what came out of the Ku Klux Klan Act of 1871.
So let's move forward on that. I want to talk about a little bit about vicarious liability. Can a police department be held vicariously liable for the actions of its individual officers?
So this is a organizational chart for the city of Seattle Police circa 2015. And of course, the city itself would be the entity at the top. And in our negligence cases, we know that if you're in the course and scope of your job duties, which these officers almost inevitably are, that the city would, or whatever government it is, would be held responsible simply based on the vicarious liability of their officers. And that is absolutely not the case under 1983, and an important consideration in handling those cases. Instead, there's another path to holding the government responsible for the acts of the individuals. And it's called a Monell liability based upon a case called Monell. And it's an uphill battle to ever establish Monell liability, because you've either got to show that the policy that's at issue is unconstitutional on its face, right? No police department has a written policy that says we're going to shoot the blacks and browns when they're not causing any risk of harm to us. You're never going to find that policy. So then you're tasked with a challenging proposition of unearthing a series of events over time so you can prove a pattern or practice that's so widespread and long-standing that it can be equated to be policy. And you can't do it with a single incident. So no matter how bad a single incident may be of police abuse that causes injury or death, that's not going to get you to Monell liability.
And so what is going to get you to Monell liability?
Well, let's talk about what will get you there. And then let's also raise a really, I think, unfortunately important question about the usefulness of a Monell claim. You got to do a lot of discovery to prove a Monell claim, because you're rarely going to find a facially unconstitutional recorded policy or training. So if you're talking about use of force, you're going to be looking at reported use of force incidents at the agency over a period of years. And guess what, right? There are good cops, just like there are good doctors, and there are good shoots, right?
Yeah.
Actor justifiably presented an imminent risk of serious injury or death to the officer, and to protect themselves and anyone in the near vicinity, they had to use the deadly force and take the life. So you got to comb through these documents then and have someone knowledgeable about what constitutes excessive force, such as someone who's done these investigations at agencies in the past. And you got to cull out and find a group that shows there were unconstitutional uses of force, and preferably that there was a lack of discipline as a result of those unconstitutional uses of force. Now, we handled a case at Strict Matter. It wasn't the Jeff Nelson case, but we handled a shooting death of a Samoan American youngster by another officer at the city of Auburn. And we did this discovery. And what we found was virtually no discipline of any officer on the force for years as a result of use of force. And we got those incident reports and the complaints that were filed and the investigation results from the city of Auburn. And, you know, some of the uses were justified, but a lot of them were not. And so at the end of the day, we felt that we had evidence to prove a pattern or practice of unlawful use of force by City of Auburn police officers with essentially no discipline ever.
And was that the case you worked with Gemma Zanowski here?
It was. That was
Yeah.
The Strickland case, Enosa Strickland Jr.
Yeah.
Versus the City of Auburn and Kenneth Lyman. And I tell you, it's interesting because in my opinion, Lyman's history with the city was very similar to Jeff Nelson, the officer who was recently convicted of homicide in our state. And it's interesting, the outcomes. Nelson was prosecuted by a state group of prosecutors who, I understand, is still reviewing the decisions by prosecuting attorneys not to charge these officers over a number of years. If that's the case with Officer Lyman in the Strickland case, if it's under review, I don't know. We don't know what's going on with those prosecutors right now. Jeff Nelson got a jail sentence Lyman quit the force and quit police work, which I don't think is necessarily as appropriate as a conviction. As the facts were that we alleged in Strickland, but it was an interesting outcome that he quit shortly before we scheduled his deposition, resigned from the force, and does not do police work today. Let's talk briefly about this issue of whether it's worth it to pursue Monell liability. And we've struggled with this question on several cases at Strip Matter. And the thing to understand is after you do all that work and prove it up, there's a good chance that it's not going to benefit you. The main problem is that in federal court, in the Ninth Circuit in particular, there have been bifurcation motions that have been made that appeal to the district court judges because you have to have a finding of an underlying constitutional violation before Monell becomes relevant. By the way, you got to prove that the Monell policy or pattern of practice was a significant contributing cause of the underlying constitutional violation. So the court likes to bifurcate it and force you to try the case against the individual first before you get to the Monell claim. Well, let's think about that. All that great evidence that you spent all that time cultivating may not be relevant in the individual case and probably isn't coming into evidence. It is helpful to learn the contours of the culture and how bad the department is. I think it can sometimes help you, but it's a lot of effort for probably little effective benefit on your claim against the individual. So the court's going to force you to try the individual first. And when do you think they're going to decide, the court's going to let the jury decide the damages? Not after the Monell second trial. It's at the first trial. So the damages are going to be established without the evidence of a widespread pattern or practice of constitutional violations. And a good defense lawyer is going to file this bifurcation motion every time. I've seen it denied very rarely in the Ninth Circuit reported cases. Well, let's just say you convince the judge. It would seem like if you defeated summary judgment on Monell liability and Monell causation, right? You've raised a fact question on whether the culture, the pattern, the practice there was actually a cause of this specific case of brutality. You'd hope that the judge might realize that it makes sense to allow that evidence to come in together. But what's a really good defense lawyer going to do? Well, in the Strickland case, what we were threatened with was an admission of Monell liability. And so it's just like admitting the car wreck, right?
Yeah.
They want to keep all that evidence out.
Yeah,
And
so you keep all the historical data out by acknowledging liability, and you defeat the whole purpose of what Monell's supposed to
Right.
serve. Yeah, that makes sense.
You found a lot of good civil rights lawyers. In fact, some of my best buddies who do this work tell me they have never pursued Monell claims. So I think it's a balancing test that you need to consider when it comes to Monell liability. And I will tell you the reason why it's rarely pursued is that the law in most jurisdictions, local, state, or otherwise, tends to indemnify these officers for 1983 violations. And so as a result, you don't have to worry about proving vicarious. You don't have to worry about proving Monell, as long as you've got the indemnification. If for some reason it's not there, you got to still pursue the Monell, because otherwise you may not be able to get the compensation that the victim, your client, deserves. You don't want to ask me about damages now, do you, Mo?
I do want to ask you a little bit about damages. I mean, what kind of damages can I get, a family can get on?
Okay, there's two types of damages, compensatory and injunctive, right? Sometimes you can actually obtain injunctive relief of say, an ongoing.
But that's rare.
It's rare that it happens. It's rare that it gets ordered. There's no damage law that is specifically attached to Section 1983 with one exception. So what happens is you look to the state's tort law for the damages. I didn't put this in the written materials, but you also look to the state's tort law for the statutes of limitation. So in our state, we've got 3 years to bring these cases, and the same economic and non-economic damages that are available in injury cases, in state law cases in Washington apply, are available. Same is true of wrongful death damages that would under state law in Washington. That's the measure of damages, with the one exception that I told you about, which is an element of damages that we do not have in tort law in Washington state, but does exist to punish bad actors under 1983. It's the only federal damage law that applies to these cases. Intentional harm, bad intent, reckless misconduct will all support punitive damage claims under 1983. The caveat is that you cannot get them awarded against the government, only against the individual. But it's an important tool for flagrant violations of constitutional law that should be in mind whenever you're handling these cases. So, Mo, you've been asking all the questions.
Yes, sir.
I want to flip the script now. We got technically about 5 minutes left. And so I'm glad to let you talk a bit more. And I want you to tell us a little bit about what you know about this young man, Derek Dwayne Clark Jr.
Young man, he's a son, a father, a brother, a nephew, a decent human being. He was driving his vehicle on the night of June 18th, 2022 in Clackamas County, which is a suburb of Portland. And he was following the traffic laws, and he was pursued by 2 officers. He did not stop. He fled in his vehicle, and they pursued him.
Well, let me stop you there if you
Yeah.
would. You know, you represent Derek's family. That's why we're talking about this case. And you filed a complaint that had a chronological timeline of the events. And I pulled one of the illustrations that are embedded in that complaint. Can you tell us the significance of what we see on the screen?
The significance of what you see on the screen is this is right after Derek was rear-ended twice by a sheriff's deputy and screamed at to get out of the car and to show his hands. And Derek ran away from the officers. This is the moment he is running across the eyesight of one of the police officers, a state trooper. And
are the blue spots officers and the yellow spot him?
Correct. So the blue spot with the red circle is the officer whose camera you see on the left-hand side, and the other officer is positioned to the right of the cruiser. And Derek is the orange circle, and he is running across the roadway. He is not facing the officers. He is not pointing anything to the officer. Now, Derek does have a firearm.
But he's got a gun, right?
He's got a gun. He's got a gun in his left hand. He's got a gun.
So why isn't it justified?
Because you can't just shoot a person who's running away, even if they're carrying a gun, for a couple of reasons. One, they have to have done something with the gun to create a threat to the safety of the police officers, which he did nothing. And second, Oregon's an open carry state. So for all intent purposes, what he's doing right now is he's running away, carrying what most gun-loving people would say is a tool in his left hand.
Well, didn't he just shoot over the shoulder back at the officers? Wasn't that a justification for killing him that night?
No, he can't shoot. What he did was he ran across the road. He was not even given a warning that deadly force was going to be used. And immediately in the picture below, you see that they started shooting at him. And as he crossed the roadway, he threw the gun over the fence, and they continued to hunt him down and shoot him in the back and strike him.
Well, how many
And
times they shoot him after he threw the gun down?
one, two, I think 5 or 6. Pop, 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 pop. Something
And
like
was
that.
one of those a lethal shot?
Yes, sir.
His life.
Yes, sir.
All right. Now, this is an odd looking thing. Looks like an X-ray of so. What is that, man?
Well, so what this is after they shoot Derek, and that's Derek to the right. That's Derek's body. That's where he's laying. That is where he ultimately comes to rest and passes. What the
And what
police
are all those
officers,
guys doing? What are those
those
guys?
guys are the SWAT team that showed up after they shot Derek, and they gathered and collected near his body, and they decided to throw explosives at him, send a dog
After he
to
was
maul him
fatally shot and down.
after they fatally shot him.
And what else did they do?
They talked about him. They
How?
laughed at him. They called him an old boy. They called him a dead deer. They called him an animal. They sat there, laughed.
Did they say some janky SH was going down?
They said there's some janky shit about to happen. That's
Well,
exactly what they said, Ed.
what did they say about probable cause?
They said we'll eventually have that. That's what they said.
Was there any probable cause for the initial stop?
No,
Well,
none.
what about the dog?
You know,
What did they do with the dog?
they sent the dog to maul him
When?
after they threw both explosives at him.
How long after he was fatally shot?
I would say about 45 minutes, maybe an hour, hour and 15.
And can you describe for us the nature of the conversations of the multiple SWAT team officers gathered there that were all captured on their body cams for the most part?
Yeah, the nature of the conversations was almost like a relaxed nature. Like we're just kind of kicking back and chilling, like almost like we're at a bar and we're just having a conversation. And while we're having this conversation, calling this human being, the son of a mother, a father, a brother, referring to him like he's an animal, and they're talking about him in just sort of just this casual way. And there is no sense of urgency, no sense of care. That's what you get, and all of it's sort of recorded on the video.
Why does this incident have anything to do with the Ku Klux Klan Act and conspiracy law, which is one thing we haven't talked about?
Because it's a modern day lynching, Ed. That's what it is.
Well, what does 42 USC 1985
Oh,
allow for?
well, that's an interesting statute. That says if you conspire to deprive an individual of their civil rights, okay, if you conspire and you do so with racial animus, then you can bring a private cause of action under 42 USC 1985, which is a conspiracy statute. And the allegation that we have made, which at this point has survived the motion to dismiss, is that these officers, by gathering over there, speaking in derogatory and racist ways about Derek and using force against him while he lay there, that they conspired to deprive him of his constitutional rights with racial animus. Animus because they're using words like he's an animal, a dead deer, a janky shit, old boy. When they refer to him that way, that is what you can reasonably construe all of that to mean.
And does the Ninth Circuit allow a conspiracy to survive SJ if the officers, in other words, acquiesce to the bad behavior?
Yes, it does. And essentially, there is law that says that if you are present and you're an integral participant of what is happening, which is what the officers are doing, then it can be inferred that you have agreed to be part of the conspiracy. So even if you're not the officers that are using the words, but you're involved in the process, you're an integral participation in a force that is being used. You are present when someone is being referred to in these ways, then yes, you do.
Thanks for sharing that. We're getting close on time. I'm going to sprint through these last screens. I just want you all to know that that illustration is of a Klan rally in Seattle, Washington in 1923. And the things Mo has discussed in this Clark versus Clackamas County, Oregon case are unfortunately akin to that, where groups conspire based on race to violate the civil rights of our citizens. The 11th Amendment means you can't sue the state, but you can sue the officials or employees. So you got to figure out who actually violated the rights and sue them individually. Attorney's fees can be awarded under 1988. It's an important aspect of your damages that you should carefully track and have available at the time of mediation. Not going to dwell on negligence, but you can bring a negligence case hand in hand with the 1983 claim. You may want to include 1983 despite its challenges, because it gets you to federal court, which may be a favorable forum as opposed to the county where it occurred. Don't remember you got all the state law negligence defenses that you've got to tend to when you're analyzing the case in that regard. I don't know if we have questions. Let's see, I got some stuff here in the chat. Somebody says this all sounds very cynical. What's the antidote? 1983 is the antidote. Is the best antidote we have. 1983, 1985, and 1988.
And voting.
Okay, so that's all the questions I saw. Does anybody else have any questions at the time?
No, but this was wonderful. Thank you, Ed, for taking the time to have this discussion. Very productive to have a CLE credit of this kind, which is an equity CLE required by the Washington State Bar Association. If you have questions after the fact, feel free to just email us, and we have no problem. Ed and I can answer those for you. Please make sure you enter your WSBA number in the credit so that you can receive credit for this. Thank you.
Thanks, Mo. Thanks everyone for joining us. We really appreciate it.
Thank you so much. Thank you, Ed. Great presentation. And as Mo said, please put your bar number in the chat. Thanks so much. Have a great day, everyone.